What happens when a president claims an emergency is so urgent that the usual rules of trade and taxation can be rewritten overnight? And what happens when businesses insist that only Congress can do that? This script walks through a high-stakes legal clash over tariffs. It's framed as a courtroom showdown about where presidential power ends and congressional authority begins. At the center is a contested use of the International Emergency Economic Powers Act, a law historically associated with sanctions and financial restrictions rather than across-the-board import taxes. The story starts in the opening months of the Trump administration, when the White House publicly described two threats as both immediate and national in scope. One threat was the flow of illegal drugs, especially opioids and precursor chemicals, entering the country through routes connected to Canada, Mexico, and China. The other threat was economic, focused on persistent trade deficits, pressure on domestic manufacturing, and worries about fragile supply chains. In the administration's telling, these were not ordinary policy problems that could wait for slow negotiations or incremental legislation. They were framed as emergencies that required rapid leverage. And leverage meant using the tools of the executive branch to change incentives fast. The president issued emergency declarations designed to unlock special statutory authorities that can be triggered when national security or foreign policy risks escalate. That choice set up the main legal question that would follow, because the tool chosen was not a traditional tariff statute written for revenue policy. The statute the president relied on was the International Emergency Economic Powers Act, often shortened to IEEPA. Under IEEPA, when a national emergency is declared with respect to an unusual and extraordinary foreign threat, the president can take actions aimed at restricting certain kinds of economic activity. Historically, the best-known uses of IEEPA have involved blocking assets, limiting financial transactions, and applying targeted economic pressure against foreign actors. The administration argued that IEEPA's authorization to regulate certain economic dealings could extend to the import stream itself. In practical terms, the White House treated the word regulate as flexible enough to include imposing tariffs as a form of pressure, even though tariffs function as taxes collected at the border. That interpretation mattered because tariffs do not just influence behavior, they raise revenue and reshape the entire pricing structure of imports. The result was a set of sweeping import penalties that reached far beyond the narrow, targeted sanctions most observers associate with IEEPA. First came the tariff measures tied to drug trafficking concerns aimed at nearby trading partners. The president imposed a tariff of 25% on most goods imported from Canada and Mexico, presenting it as leverage to compel stronger border enforcement and cooperation. The theory was straightforward: make commerce more expensive until governments change behavior. Do it immediately rather than waiting for Congress to pass a new law. Around the same time, similar emergency logic was applied to China, again tied to narcotics narratives. A 10% tariff was placed on most imports from China, with the stated aim of pressuring action against the production and export of illegal drugs and precursors. The tariffs were positioned as a punishment and an incentive at once, using the American market as the bargaining chip. For importers and retailers, it also meant costs that landed quickly and unpredictably on contracts written months earlier. Then the administration widened the scope beyond drug-related pressure and into structural trade policy. Separate from the narcotics framing, the president targeted the trade deficit itself, describing it as a threat to national economic stability and industrial capacity. A tariff of at least 10% was applied to nearly all imports entering the country, as a broad shield for domestic manufacturing and a lever to rebalance global trade terms. For dozens of specific countries, the rates were set higher, and administration frequently adjusted the numbers, creating a shifting environment for businesses trying to price goods and plan inventory. From the business perspective, the immediate issue was not simply higher costs, but the way those costs were imposed. Companies argued that if the executive branch could impose large, adjustable, and potentially indefinite tariffs by citing emergency power. Then the constitutional system of taxation and trade legislation was being bypassed. In their view, Congress holds the power to set tariffs, write tax rules, and decide when the country should raise revenue at the border. What alarmed them most was the sense that the rates, the scope, and the duration of the tariffs were limited mainly by presidential choice rather than by clear statutory boundaries. That concern quickly turned into litigation, and the legal fight split into two tracks. One set of plaintiffs, commonly referred to in this narrative as the learning resources plaintiffs, filed suit in the federal district court in the District of Columbia. Their claim was that the statute being cited did not actually authorize tariffs at all, and that the tariffs were therefore unlawful, even if the emergency declarations remained in place. The case became an early test of whether general emergency language could be stretched to cover a power as specific as imposing import taxes. In that district court case, the judge agreed with the plaintiffs at the preliminary stage. The court issued a preliminary injunction blocking the tariffs, reasoning that IEEPA did not grant the president the power to impose tariffs, regardless of how severe the claimed emergency might be. The key idea was that the statute's text and history did not show an intent by Congress to hand over tariff authority to the executive branch. The government responded by challenging not only the merits but also the forum. It argued that because the dispute centered on tariffs and import measures, it belonged in the specialized court of international trade rather than in a general federal district court. The venue mattered because trade cases often follow specialized jurisdictional paths and specialized review structures. The district court denied the motion to transfer, keeping the case where it was for the moment and setting up a second layer of dispute over where such challenges must be filed. At the same time, a second group of plaintiffs pursued a different strategy. In a case styled as VOS elections, they filed directly in the Court of International Trade, aiming to avoid a jurisdiction fight and to meet the government on the terrain it preferred. Their argument on the substance mirrored the first case. IEEPA may allow regulation of economic transactions in emergencies, but it does not contain a clear grant of power to impose tariffs as a revenue measure. By filing in the specialized court, they forced an early merits decision in the venue most associated with customs and import disputes. In the Court of International Trade, the plaintiffs won as well. The court granted summary judgment against the government, effectively concluding that under the law as written, the president could not do what was done here. That ruling treated tariffs as a distinct governmental action that requires clear congressional authorization, not a mere subset of generalized regulatory power. With two different courts reaching similar conclusions through different procedural paths, the issue was now set for a higher appellate confrontation. The government appealed. The fights moved to the United States Court of Appeals for the Federal Circuit, which hears many trade-related appeals. The court took the unusual step of sitting en banc, meaning the full active bench participated, signaling how consequential the question was. At that point, the dispute had sharpened into a single, high-impact interpretive problem. What did Congress mean in IEEPA when it used language about regulating importation? The next step would determine whether that phrase could plausibly include tariffs, or whether tariffs were a line the executive branch could not cross without a direct act of Congress.